advocates. Bill is not relating to courts or high courts or Supreme Court function. Our attempt while deliberating on this amendment bill is to strengthen the advocates of our country and the system of jurisprudence in our country. This advocate amendment bill clearly mentions two things. One is to repeal all obsolete laws of pre-independence acts, not totally, but which have lost their utility. This should be borne in mind. All the law is not being abolished. Those laws which have lost its utility are being removed. And Government of India is doing this in consultation with Bar Council of India. So these two things have to be borne in mind when we are deliberating on this subject. We know the history of Indian High Courts, how it was formed by an enactment of British Parliament in 1861, and subsequently what development has taken place in between. While going through the bill, sir, the definition of tout is also given. A tout means a person who procures in consideration of any remuneration moving from any legal practitioner. The employment of the legal practitioner in any legal business. This is the first part of the definition who the tout is. But subsequently, in the second subpara it is mentioned, the purpose of such procurement frequents the presence of civil or criminal courts or of revenue offices or railway stations, landing stages, lodging places or other places of public resort. So in that respect, it has been very clearly mentioned in the bill that those touts who operate for lower courts, they need to be apprehended, they need to be named, they need their names to be published, and they can be prosecuted. The impression of the government is, or the earlier law was, that touts do not exist in high courts. They don't exist in Supreme Courts. We should not presume that touts do exist. But my only humble suggestion is that a beginning is being made. It was there in earlier enactment, which is now getting incorporated in this amendment, in the Advocates Amendment Law, through this bill. And the best part is, the previous law which was there, now one cohesive law is coming into existence. This was introduced in Rajya Sabha last August. It was passed in also Rajya Sabha last August. It amends the Advocates Act 1961. This bill repeals certain sections related to touts under the Legal Practitioner Act of 1879. The bill provides that every High Court, District Court, Session Judge, District Magistrate and Revenue Officer not below the rank of District Collector can frame and publish list of touts. This bill makes the act of tout punishable. Means cases can be filed against them, they can be apprehended. But there are two aspects on which I would like to deliberate. One is the practitioner or the legal practitioners, the advocates, what need to be done for them. And the second is about 45, Rule 45 also is mentioned. That is relating to regulating legal education. That also needs to be looked into, which has not been addressed in this bill. There is Rule 36, which imposes three primary restrictions on lawyers. Firstly, lawyers are not allowed to promote themselves directly or indirectly. Second is, if a lawyer is involved in a case, they cannot advertise themselves in the media, newspapers, display their photo, or make inspirational comments. Question is, who is going to question the lawyers? Who is going to lodge a complaint against this type of dereliction of duty? Our expectation is the Bar Council of India will take cognizance of it and will deliberate on it, will take action on it. But are they doing that? During last 20, 30 years since the inception of Bar Council of India, how many such cases has been deliberated by the Bar Council? Not a single complaint has been lodged, or has it been lodged and it has been glossed over? In consultation with the Bar Council of India, government is repealing the Legal Practitioners Act of 1879. Now the legal profession will be regulated by a single act. It is their responsibility to have quality lawyers. Section 36 of the 1879 Act is incorporated in the Advocates Act 1961. Some suggestions I have to make here for consideration of the government. Reform is a continuous process, and it has to be done with tune of time. There should be provisions for professional development of the lawyers in the Advocates Act 1961. There is no such provision even today, that how professionally an advocate can enrich himself. Technology has become all pervasive now. There are many emerging frontiers of law. Law to regulate telecom sector, law on intellectual property rights, Arbitration Act are some of those. Now, online dispute resolution has become a practice. Lawyers need to update with the latest development in the field of technology. Shouldn't we bring in these aspects in our amendment? How to legalize, how to make them more professional, that aspect we are missing. There should be, I would suggest, there should be, government may consider, there should be a national electronic register for advocates. Anyone, anywhere in the country can sit down and find out who are the advocates. Why should they take the help of touts? Or why should we presume that without a middleman we cannot approach a lawyer? We do not have any such register. The Law Commission in its 184th report had suggested as such. There should be a single database. This would be good to bring social welfare schemes for the lawyers also, because you have a single database of the whole country. There should be a digital interface between the advocates and the clients. This will eliminate the need for Section 45A in itself. Why do we need middlemen when we can have an electronic platform that can connect advocates and clients? I have a query also. Do we need intermediary that is being incorporated as Section 55 in the Advocates Act after repealing Section 36? When we have digital interface, is this provision necessary? Finally, I would also for an Advocates Protection Act. Since states have enacted such law, Minister for Environment, Forest is also present here in this house. Rajasthan has enacted that law. The present law minister is also from Rajasthan. Rajasthan has enacted a state law. I'm not aware how that law is functioning and how much protection this advocate protection law has given. But it
the law the government lost.
But I think it is necessary, because at times we also come across number of news where lawyers are attacked or lawyers are threatened or intimidated. Advocates need to practice fearlessly. The advocates, after all, are officers of the court. They are important stakeholders in the administration of justice. I believe the suggestions given shall get utmost attention of the government. The other part which I would like to mention is relating to the academic, regulating the legal education that needs to be strengthened. Large number of law colleges are being opened. But what is the quality of the lawyers? We all know. When the quality of the lawyers that are coming out from the law colleges, it is not only affecting the bar, it is also affecting the bench. So keeping that in mind, I think it is of greater need to look into these aspects also and to bring a comprehensive law in favor of the advocate and our advocacy system. Thank you, sir.